Picture an elderly man, a retired serviceman, a lifetime of standing at gates for this country. One morning he walks to his own property and finds a new lock on the gate. Strangers inside. Men who tell him, without showing a single paper, bank's orders, leave. No court order, no possession notice, no auction yet. This is before any sale. He does what every citizen is taught to do. He goes to the police station. And the officer says 3 words. The matter is in court. We cannot interfere. Today I will show you why those 3 words are legally wrong, why a pending case is not a license to trespass, and what a citizen can do, step by step, when the protectors look away. Welcome back to Dr. Mind Forensics, the darkest arm of the elephant, and the episode where the ant learns that even inaction can be turned into evidence. Let's be precise because precision is protection. Yes, SARFAESI allows a bank to take possession of secured property, but the word possession hides a ladder of legal steps, and the muscle at the gate skips all of them. Rung 1, the possession notice. After the 60 days expire, the bank may take symbolic possession. A notice delivered, affixed on the property, published in 2 newspapers. Episode 3 territory. Symbolic possession is paperwork. It is not meant at your gate. Rung 2, the magistrate's order. Here is the rung everyone must memorize. If the bank wants physical possession, actually entering, actually evicting, and the borrower does not hand it over, the bank cannot use force on its own. The act sends the bank to the district magistrate or chief metropolitan magistrate under Section 14 for an order. Only then, and usually with an officer appointed for the purpose, can physical possession be taken. Rung 3, after the order. Even then, an inventory, a punchnama, receipts for what is inside, process, witnessed, recorded, accountable. So when strangers change your locks before any magistrate's order, sometimes before any auction, sometimes before even a valid possession notice, that is not bank recovery. The law has an older, simpler name for it, criminal trespass. And if they enter a dwelling, threaten, or damage, the names get more serious. The uniform those men claim to act for does not matter. A bank has no private army in law. Nobody does. And this is not my opinion. This is settled, spoken, national law. In ICICI Bank v. Prakash Kaur, the Supreme Court condemned the use of muscle men for recovery in the strongest language a court uses, holding that a bank cannot take the law into its own hands, and that recovery must proceed through legal means, not hired force. In later cases, the court went further, holding banks vicariously responsible for the actions of their recovery agents. The Reserve Bank of India followed with binding circulars. Recovery agents must be trained and certified, must carry identification and authorization, must observe strict codes of conduct, no intimidation, no humiliation, no odd-hour visits, no force. A bank whose agents violate these norms faces regulatory consequences in addition to criminal law. 3 questions. If they cannot produce these papers, then whatever is happening at that gate, it is not law. Document their answers or their silence. And a word of care, because I say this as a doctor as much as anything else, never physically confront such men. The goal is never the gate, it is the record. You win this at a desk, not at a gate. Now the second betrayal, the one that breaks people more than the trespass itself. You report a crime and the police refuse, saying the matter is in court. Here is the law, and I want every viewer to know it cold. 1. Civil and criminal are separate rails. A pending case before a tribunal about the loan does not suspend the criminal law about trespass. A dispute over money in one forum is not permission for force on the ground. The 2 proceedings run on different tracks, and one does not switch off the other. 2. Registration is not optional. In Lalita Kumari, a Constitution bench of the Supreme Court held that when a complaint discloses a cognizable offense, the police must register it, not may, must. Forcible entry, criminal trespass, intimidation, these are cognizados. Sub judice appears nowhere in that judgment as an exception, because it is not one. 3. The escalation ladder. So what do you do when the station house refuses? You climb. Calmly, in writing, keeping copies of everything. Rung 1. Written complaint at the police station. Insist on an acknowledgement or send it by registered post so receipt is provable. Rung 2. Refused? Send the complaint to the superintendent of police. The law expressly provides this route when an officer in charge refuses. Rung 3. Still nothing? Apply to the magistrate to direct an investigation. Now a judicial officer is watching the police file. Rung 4. In parallel, the State Police Complaints Authority. And, where dignity and liberty are violated, the Human Rights Commission. And remember, senior citizens have special statutory protections. Their complaints carry additional weight and additional forms. And here is the forensic twist that turns this episode from grievance into strategy. Every refusal you climb past becomes paper. The unregistered complaint, the postal receipt, the SP petition, the magistrate's application. Together they prove two things at once: that the trespass happened and that the machinery around the elephant looked away. When the property case reaches the tribunal, that paper trail doesn't just support the criminal complaint, it paints the pattern. A tribunal that sees possession taken by muscle and police that would not even register it understands exactly what kind of recovery this was. The rules so far: 1. Tribunals discount indignation. They cannot discount an unserved notice. 2. The bank's silence is your loudest evidence. 3. Presumptions die when the record speaks. 4. Cheap auctions are not accidents. And today, Rule 5. Next Monday, everything comes together. Episode 6, The Ant's Weapon. How a challenge under Section 17 is actually built. The 45-day clock. Why grounds are stacked like independent pillars so the case stands even if one falls. And the single most important race in the whole battle, reaching the tribunal before the sale is confirmed. If someone you know found strangers on their property with no papers to show, send them this video today and tell them, start the written record now. Every day of delay is a gift to the elephant. Subscribe, press the bell, see you Monday. Nothing in this video is legal advice, and nothing here is a comment on any pending matter. Consult a qualified advocate for your own case. Jai Hind.